Okay, Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, Prof. Sestel and Prof. Rimawan from Faculty of Economic and Business, Gajah Mada University. Thank you very much for your time to join with us to carry out the lecture about the law and politics. Today, we have a time to discuss about the impact economic to the law in lawmaking process. And to start now, we have 2 hours today, and we will lead by Ibu I from Master in Law, Gajah Mada University. And I think it's better if Bu Ye directly lead our discussion for today. And for the participant, please be prepared with the question, the interactive question for both speaker, international speaker today. I think the time is yours, Bu Ye. Please.
Thank you, Pak Khotib. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan, salam sejahtera, and God bless us. Thank you very much for sending, give me the moment, yeah. So today is actually we will have a very good session because this is the second guest lecture series for our center, Law and Politics subject. So for Pak Rimawan and Prof. Chester, this is a subject, mandatory subject for students in Master in Law, particularly in the first semester, as we have discussed serial topic in this subject already. So we do understand that talking about law and politics, we comprise 3 main issues. The first one with regard to the legal formal mechanism of lawmaking process, which lead by the government and parliament, as mentioned in 2 significant laws, the law number 12/2011 and the law number 15/2019. However, evidentiary, there are a significant process of lawmaking, which is not only informal or in parliament only, but outside parliament is also very important. So this second issue that we discuss is about the influencing or the influence factor or the influence interest come from the decision-making law process. So it's regarded to the different issues and claim-making issues. So the third issue that we discuss as well is about the related judiciary lawmaking process and the activism in judiciary lawmaking process. So 3 big issues that we discuss in law and politics. Today, we will focusing on how economic interests, whether in national or even in international or transnational interests, influence the lawmaking process. So we want to also look at whether Indonesian lawmaking process also influenced by the economic and international interests. So we do have 2 distinguished lectures today. The first one is Prof. Chester Brown. So thank you, Prof. Chester, to join with us. So I will introduce you a bit. Yeah, Professor Charles Brown is a professor of international law and international arbitration at the University of Sydney Law School, and also the Law School Director of Global Engagement. He is also the barrister at 7 Wentworth Selborne Chamber, Sydney, and an overseas member of Essex Court Chamber, London. He teaches and research in the field of public international law, international dispute settlement, international arbitration, international investment law, and private international law. So he mainly practiced in this field and has been involved as counsel, expert, and arbitrators in various proceedings, including before the International Court of Justice, the Iran United States Claims Tribunal, interstate and investor state tribunal, as well as the interstate conciliation proceeding, international commercial arbitration, and domestic court proceeding. So there are a lot of informations about Professor Chester Brown, so you can find out by yourself, guys. Yeah. So the second one is actually our fellow, Dr. Rimawan Pradipto. So Dr. Rimawan is the lecturer, yeah, in Faculty of Economic. Since November 2018, Dr. Rimawan actually as the head of Department of Economic in UGM, and then he concentrates in law and economic, game theory, and experimental economic. Besides, as the lecturer in Faculty of Economic of UGM, Pak Rimawan also very active, yeah, particularly during COVID. Pak Rimawan is the founders of Sonjo. Sonjo is kind of like, later Pak Rimawan will introduce, but I actually follow Pak Rimawan activities about Sonjo. I think it's part of the, kind of like coordinating the small business entrepreneurs that doing, business online. Yeah. So, and Pak Rimawan also a commissaris Harja. I'm sorry. Am I audible? I'm sorry. Am I audible? Thank you. So, and then also various position that Pak Rimawan have, it's showing that he's actually not only as academician, but also the organic academician. He is also very active in advocacy for corruptions in Indonesia. So there are two distinguished professors that will share their expertise for us, particularly to answer the question how actually the international or national economic interests influence the law making process. So first, I will give the time for Pak Rimawan to give a context of Indonesian's lawmaking process, whether the economic influence might be influenced so strongly, particularly with regard to the recent law. Yeah, Undang-Undang Cipta Kerja is a very famous law that established and then has a controversy about it. And then later on, I will give time for Prof. Chester to also give an interesting topic that become his expertise. So time is yours, Pak Rimawan. Thank you very much.
Thank you. Good afternoon, ladies and gentlemen. So I would like to share my materials here. So what I want to discuss today is two parts. The first part is a situation of the economy in Indonesia in the last 200 years. And secondly, after the COVID or prior to the COVID, there are so many changes, drastic changes actually. And then afterward, what's going on after the COVID, and what is the way forward that we see, that we're looking for. So it's very interesting to see the current situation at the moment that will shift a lot in terms of the, what would happen in the future, basically in Indonesia. Although I'm a bit skeptical about, whether will it be possible for our government to switch so rapidly, because at this time, actually, later on, I will show to you that actually we moved to the wrong direction. All along, we moved to the wrong direction, but now we want to move to the right direction. And I don't think that will be very easy, basically, but it seems to me that the government hasn't thinking through about the impact or the consequence of the move that they are trying to do now. Okay, let me start with what's going on with the economy in the last 200 years of the economy in Indonesia. So basically, this is we have three problems in economy in Indonesia. First is that we don't know ourselves and we don't know our enemy. This is the worst scenario ever. So basically we don't, it's basically the last part of the Sun Tzu recommendation, because he said, if you know your enemies and know yourself, you never be in peril in 100 battles. But the situation is totally different for us, because we don't know ourselves and we don't know our enemy. The question is that, is it true that we don't know ourselves? It seems quite naive in saying that, or probably this is a bold statement, but if we take a look, the simple one is that we don't have a solid single identity number. We can ask Pak Chester later on, is there any single identity number in Australia? Of course, yes. In everywhere in the world, in the developed countries, they always have a single identity number. That's why, like in the UK, for instance, you may live in the UK without ID, but they knows exactly what you're doing, how much tax you have, how much money that you earn every month and things like that. They knew. Now, the second problem is that if you look at the picture there, that's typical, the situation that we have. Our economy is, the majority of the economy is basically dominated by the informal sector. It was about 50 to 60% of the Indonesian GDP is part of the informal sector. And lastly, we have problem with institutional aspect. So it's just like a cheese. Yeah, if you can see that, that's the situation that we have. So these are some of the challenges that we have. So we have a dualism in the institutional system. So in terms of the technological progress, we may use the Mark Zuckerberg technology, but the administration system, I'm sorry to say, it is still in Napoleon Bonaparte era. The same thing occurs for the democracy. The bureaucracy is still in the old system, but then the way we're trying to work with the democracy is quite advanced. So this is some kind of a problem that we have as well. And lastly, what we have is the heterogeneity in the incentive system, which is rarely people talk about this in Indonesia, but actually this is the main problem. Why is it that in Indonesia we have a problematic in coordination? Why is it that it's so difficult to coordinate? It's simple, because each of the public sector has different way of the incentive system. The principle in economics said, one of the principles in economics said, that individual behavior is sensitive towards incentive. When the incentive, you try to change your incentive, then the behavior will be different. So imagine if you have a three different incentive system, then the first thing that will occur is that it will be very difficult to do the coordination among them. Now, this is the structure of the economy in the last 200 years. So since the Dutch colonized us after the VOC, that was in 1800, basically our structure of economy doesn't change. So we still use what I call the extractive economy. But in order to be extractive economy to survive, it requires extractive economic institution. So what is that? So that's, something that's, those who are politically powerful, elite extract the resources from the rest of the society. This is what's going on. Up until now, we still use this. Yeah. Now the question is that, is there any room for us to develop what I call the inclusive economic institution, for instance? The answer is no, not so far. There is no room for that. We talk about law and order. What kind of law and order do we have? Access to education. I'm sorry, there are so many people cannot get access to the education. Opportunity for the majority of citizens and support to citizens. Yeah, that's another problem. And what about how the market works and also the support to the market? That's another problem that we have. So if we want to envisage of using the inclusive economic institution, this is still, a bridge too far, the way I put it like that. So this is the status quo bias of the development policies in Indonesia. In economics, we already talked about the endogenous growth theory, in which in the endogenous growth theory, we not only talking about the capital, but we start talking about the human capital, institution, and even the social capital. But if you see the way the government always try to, and then the narrative from the government is only two things. First is about the growth, and the second one is about the foreign direct investment. That's it. There's nothing to do with the human capital, nothing to do with institution, nothing to do with social capital. But that is the narrative since 1950s, and most economists doesn't use it any longer. And why is it, that in this day we already have indigenous growth theory, and has been implemented successfully in many countries, but we are still reluctant to do so. Another problem that we have is that we have what I call the unregulated corruption. So the way we trying to rule the corruption is just only for the public sector, but non-public sector is almost nothing. There is nothing in there. So although we ratified the UNCAC in 2003, it's much more earlier than Malaysia, for instance, but still until now we haven't implemented the private sector corruption, foreign bribery, illicit enrichment, trading of influence. Malaysia, on the other hand, they ratified the UNCAC in 2008, but then soon afterward, in 2009, they ratified several anti-corruption law, and that's to support the UNCAC agreement. And in 2017, they revised their act in order to acknowledge to implement the private sector corruption, anti-private sector corruption. So this is what's going on. If we trying to talk about this, the four recommendation of UNCAC, we always talk about this since 2009 or whatsoever, but then up until now, there is no single indication that shows that the government of Indonesia willing to embrace this recommendation. Now, the question is later on is that because we have a heterogeneity in a corporation and their compliance towards the Anti-Corruption Act, then it's create some complexity. So if we deal with a state-owned enterprise, of course they will comply with the anti-corruption law. But if you work in a domestic private enterprise, then you may not need to think about that. Okay. The same thing with the multinational corporation, especially those who are from OECD. They bound with the OECD regulation and also the requirement for them to obey the Home and the Host Anti-Corruption Act. And this is applicable. But if you are multinational corporation from non-OECD, China, India, and etc., then you don't need to comply with the Home Anti-Corruption Act. Yeah. So you operating in Indonesia, but you don't need to think about what's going on in your country. It's totally different. Now, some of the cases make us very difficult to investigate the corruption cases because the compliance from the home country is basically non-existent. So there are some cases, something like this in a corruption that occur in Indonesia. Now, the question is then, another question is that where are actually the trend of the international trend in terms of the institution? If we see it, start from 2000 year 2000, we have UNCLOS, for instance. This is for the transnational organized crime. We also have the UNCAC 2003. We also have the Jakarta Principle, anti-money laundering measures. Anti-money laundering, what I meant by anti-money laundering measures include beneficiary ownership and also PEP database, politically exposed person database. We also have automatic exchange of information, ISO 37001, Paris Accord, and also sustainable development. That is the way the international move towards that direction. Yeah. So we start from the world move towards less regulated, tend to be sustainability was not a concern, to highly regulated, and the sustainability is a paramount. This is the trend. Now, what's going on in Indonesia? We do have the similar approach, something like that, but it's only during the Reformation. It started in 1998, but then it is stopped in the end of 2019. And if you can see all of the regulation that we have, none of them is related to the act. It's just only somewhere below the act, like a presidential regulation or presidential instruction. So actually, we still need to ask ourselves, are we serious about moving to the right direction, to the direction in which we have accountability and transparency and also promoting the sustainability? I don't think this is the case. I think it's just only, we do that kind of, composing this kind of a regulation. It's just to show the world that, okay, we comply, but it's actually, we are not serious enough. Now, there are some programs that actually works very well in Indonesia. And actually we have two programs of that's champion. The first is in terms of the institution, we have two institutions, and also we have two programs here. So in terms of institution, we have KPK, and also we have the Task Force 115. So Task Force 115 deal with the anti-illegal fishing, which is whereas the KPK work especially for the natural resource protection safeguard. So this is the initiative that the KPK did. It was in 2015 until 2019, and then it's creating improvement, institutional improvement within the areas of the natural resource management. If we talk about the natural resource management, it's actually cover 18 sector sector in Indonesia, which is huge actually, because it resembles about how our economy is basically the still extractive economy. Now, this is the example of how the Task Force 115 works. They do the evaluation of the analysis and evaluation of foreign vessel. For instance, at that time they found 1,132 vessel has a problem in terms of the permit and etc. And also we can see the detection rate and also the conviction rate improved dramatically since 2015 because of the existence of the Task Force 115. These are some of the foreign vessels that's been caught in Indonesia. And many of them were trying to be captured by other authorities, but failed. For instance, like the Silver Sea, they were caught twice by the Chinese authority, but they can slip it through. Huali, the same thing. It was chased by the Argentinian army at that time, but they were caught in Indonesia. Okay, this is some of remarkable performance actually shows by the Task Force 115. And on top of that, actually we become the leader. We become the trendsetter of the anti-illegal fishing movement. But then, unfortunately, this just stopped until end of 2019. In the second term of Pak Jokowi, everything changed. What we have is this one. So from 2014 and 2019, we are mastering we have two institutions that's become the trendsetter. One is the trendsetter of anti-corruption, and the other one is the trendsetter of the anti-illegal fishing. But then, after the second term, it seems that we have forget it. We forget everything. We done we have the Act of 2019, the revised Act of the KPK. The GNP SDI has been discontinued. And then we have Omnibus Law, Task Force 115 also discontinued. And it's strange because they were all discontinued because of their performance. And this is quite dramatic. You work very well, but then afterward the political circumstances doesn't allow you to be existent. although you may be followed by other countries. So this is the dramatic things that was occur in Indonesia, and this one will make our life very difficult actually. So if you can see this, yeah. So this is the situation that we have in since the Reformation. During the Reformation, the first phase of the Reformation, that we implemented the letter of intent from the IMF. And at that time, it was 80 acts were ratified within 17 months. And why is it that this one occurred, basically? It's because it's just like lawless. There is no regulation whatsoever in Indonesia. The birth of the KPK and also the KPPU, the anti-monopoly institution, is part of the letter of intent. And when we had PPATK, so PPATK is FDIC in Indonesia. In Indonesia. Again, why is it that we have the PPATK at that time? That's because our credit card doesn't work, hasn't been accepted abroad. I remember that was in year 2000 until 2005. Why? Because the FETF says that based on the recommendation of the FETF, they put Indonesia in a red list because it is too dangerous for the anti-money laundering activities. That's why we created the PPATK. So basically, the KPPU, KPK, and PPATK was not part of our intention to build. It is the intention of the international community to push Indonesia to develop those institutions. Then the question is that, do we really need, I mean, as a nation, do we really envisage of moving our nation towards the nation which promote the integrity and the transparency in the system? I'm a bit doubt about that. Okay. Now, there are some improvement, of course, afterward in 2004 and 2019. So this is basically for 3 period, two period of presidency of the Pak SBY and also the first period of Pak Jokowi. And it's the improvement of the institutional aspect is quite tremendous, although it's not perfect, but that's, it's moving to the promising direction. However, in the end of 2019 until now, we just like a sudden reversal of the sudden deterioration of the institutional aspect. So this is the situation. It's very, very heartbreaking actually. But then that's the fact that we have at the moment. Now, then we have COVID now. This is a COVID. So in a COVID, the way we trying to model the COVID based on a game theoretical perspective is that this is like the move of the nature. The nature is like a state of the world where you make a decision. So when the nature of the state of the world change, there is only one thing that you can do, to adapt. Yeah, you need to adapt. So forget about the pre-COVID-19 economic performance, because they may not be emerged in 10 to 15 years to come. Now, COVID is not the end, because what we concern the most is after the COVID. It's just like reminiscence to the Second World War. After the Second World War, there was a dramatic change in the world economy and in the world politics. So we will have the similar things. If we recall the Second World War, for instance, it's just only 3 continents that's involved in the war. But for the COVID, all continents suffer from the COVID, and the impact, the adverse impact is tremendous. So I'm afraid that we will face, it's another state of the world, which is we need to take into consideration quite seriously, because we need to prepare what would happen in the future. And it can be seen now that, like a green or circular economy will be paramount, and also equality will be paramount as well. So that is the direction that, in my opinion, the world will move towards. Now, these are the impact of the COVID. Basically, it will create the scarcity of the capital, and that's the need for the science, and requires the improvement of the institutional aspect and everything. But most important is that we need adaptation and innovation. Okay. So what's going on in Indonesia later on? Now, this is the institutional impact of the pandemic, is that it will increase the proportion of the informal sector. It will decrease the formal sector, the contraction in formal sector, but at the same time, it will reduce the quality of the institution. Now, I just want to show that even during the pandemic, there was some corruption that I call it as a unprecedented corruption. Somebody managed to take the, willing to do a corruption for the social relief fund. It's just unimaginable that your fellow countrymen suffer from hunger, but then you're trying to take some of the money that actually belongs to them. So it's just horrendous. And this one is have been done by ministers. So we have 2 ministers have been caught in these circumstances. Okay. Now, another thing that we have is the Omnibus Law that was in the beginning of the COVID-19. I work quite substantially for the Omnibus Law, and when we check, some of the content in there is quite alarming. Actually, the way I put it like this: if we trying to sell things, if we trying to promote our economy, we still use the Introduction to Economic 101. What is that? We're trying to promote the, trying to attract the investment by using the price decision. So it's like, oh, my product is economical, so please buy my product. But we don't take into consideration about the quality of the product. So in economics, we use what I call non-price decision. This is in advanced economics. People in advanced, economics, when you discuss about this, in the elementary, you're talking about the price decision, but in an advanced topic, usually we start talking about the quality. We start talking about the R&D. So we talk about the non-price decision. So this is the problem that we have. So now I just want to show. See, this is the situation that we have at the moment. So it was adverse, at first from 2004 to 2019, there was an improvement in institutional aspect. But then in the last 2 years, there was some sort of like sudden deterioration of institutional aspect. Now, because of the international economy tend to move to the green or circular economy and promote the equality, it seems to me that we're trying to chase that. It seems to me that we're trying to embrace that. But I'm just concerned about, hey, hang on. We lose some kind of a momentum in here. It is the bureaucrats and also the politicians who put the pendulum back into the prior to the Reformation. But now we want to chase again to move to the green economy. So what is that? To me, it's just confusing, and I doubt that the government has thinking through the complexity in dealing with this. Will it be possible for the government to reinstate the KPK in the old days, in the heyday, in their top performance in 2019, prior to the revision of the KPK law? Will it be possible for the government willing to reinstate the Satgas or the Task Force 115? I'm not sure. But what do we have at the moment will not fit into the green and circular economy in the future. Okay, so the way I'm saying is that, okay, why don't we learn from when we controlling the pandemic? At the moment, we are successfully controlling the second wave of the pandemic. Why? Because we use the evidence-based policy, promoting trace test and also isolation using shelter and everything. But then can we use the same energy to do this? So in the end, this will we face this. After the pandemic, we will face this. Now the problem is that if you want, there are only two choices. If you want to do expansion, then the question is that where's the money will come from? The money will be very scarce because many countries in the world have implemented the budget deficit. So that will be very scarce in the future to get the capital, the financial capital. Now, if you cannot access that funding, then another question is that will it be possible for us to improve our efficiency? The answer is no. Why? Because it is the decision of the because we already ratified the Act 2019 to weaken the KPK, and also so that's in terms of the efficiency of the system. It is basically there is no opportunity for us to do so. But in the post-COVID pandemic, we face this problem: reform or perish. So it is up to us now to face that. So we call it in Sonjo is MAU. Everything can be done if there is MAU. MAU is MAU, or willingness or eagerness. There's nothing, we cannot talk about the business as usual anymore. So we need to talk about willingness. Willingness to what? Willingness to adapt, willingness to innovate, willingness to change. But unfortunately, I don't see any case that our government would like to embrace that, although they declare that they would like to embrace the green economy. Probably this is from me, and then later on we can discuss further. Thank you.
Thank you, Pak Rimawan ya, atau Mas Rimawan ya. I think this is a very interesting discussion. Perhaps student will question how and why in Faculty of Law student need to learn about economic. And then I think we know it, so we can avoid economic, macro and micro. And also when we discuss about the law itself, there's a very economic dimensions in law itself. Yeah, I think we have discussed a lot. And then Pak Rimawan give us a very interesting perspective about the development of legal developments today from the perspective economic justice. Yeah, actually he tried to discuss about us. There are a very interesting development, quite interesting development in the first era of Pak Jokowi. I mean in before 2011, there are a great development in law and also the legal institution with KPK, and then many things, yeah, including several issues that very influence to the economic aspect, clean economic and sustainability economic. And Pak Rimawan also discussed about it is actually influenced by international framework in many aspects. And then in some part, sometimes when we already ratify international agreements, so it's become a push for us to in line with these influences. Yeah. So thank you, Pak Rimawan. And then I hope there are a lot of things, a lot of interesting. So if you don't want to forget it, so you just write it down and then you can start to have a chat in order to raise a question or comment. Feel free to do so. And then before I give time for Pak Chester, so I forget to tell you that we will have two discussions as well today. So Pak Andi Omara is one of our lecturer. We'll give a discussion after Pak Rimawan and Pak Chester Brown. So it's about 5 minutes, and then Pak Khotib. Pak Andi is actually the lecturer of the state and governments in our faculty, and Pak Khotib is more likely discuss about the business law, but they will give a comment, yeah, to make to raise something that might be linked to our subject to discuss. Okay, so thank you, Pak Rimawan. I think it's very very interesting discussion, and I give time for Pak Chester. Pak Chester, I think we want to know also whether a similar situation happened in other area of Indonesia, in Southeast Asia or in Asia, or even in your country, and how far that's actually the international influence, international economic influence to your to lawmaking process as well in Australia or other country in Asia. So we would like to give you about similar time with Pak Rimawan, yeah, about 30 until 40 minutes. Time is yours, Pak Chester.
Yeah, well, thank you very much for the introduction, and also for the very kind invitation to join you in this class this afternoon. It's really nice to be involved in this part of your education, of your master's degree, and I'm pleased to be here today to give a talk on how transnational economic considerations influence the law-making process. Now, I've got some slides which I'll just add on to share the screen. So I think if I click share screen, and can you see my slides now? I hope that's worked. All good?
Perfectly.
Okay. Okay, very good. So the focus of my remarks this afternoon is on international investment law, which is obviously a branch of economic activity, and it's an area of a lot of lawmaking, both at the international level as well as at the domestic level. And so it's probably quite a good case study to see how economic considerations have a great impact on regulatory decisions by governments and other legal issues as well. Now, I've got a number of issues I wanted to go through, and I'll go through them as efficiently as I can in the time we have available. But I'll launch straight into it. I wanted to introduce you to the concept of what an investment is, and an investment, I suppose, and international investment law as a body of law is obviously a branch of international economic law, and it's one of the two main branches of international economic law, the other main branch being international trade law and the law of the World Trade Organization. So here I'm going to be focusing on international investment law. And we can begin by looking at this topic by sort of putting on a hat as if we were economists, and looking at how economists measure investments. Now, I'm not going to dwell on this because this is not a course in econometrics or advanced macro or microeconomics, but economists measure flows of money from one country to another. And they have a way of defining what types of flows of money they want to capture in this measurement. And the definition that's provided by an OECD publication, the OECD benchmark definition of foreign direct investment, is that they're looking to measure flows of capital which reflect the objective of establishing a lasting interest by a resident enterprise in one economy in an enterprise that is a resident in an economy other than that of the direct investor. And what economists are looking at flows of capital where there is going to be a long-term relationship between the investor and the investment enterprise in the other country, where the direct investor has a significant degree of influence on the management of the enterprise. And that can be evidenced by something like the direct or indirect ownership of 10% or more of the voting power of the enterprise. So this is how economists measure direct investments. And I've taken the trouble to show you this because this has become quite an influential way of defining investment, whereby when lawyers have had to come, and international lawyers have had to come and consider terms in a treaty where the word investment is contained in a treaty, and the treaty I'm talking about is the Convention on the Settlement of Investment Disputes between States and Nationals of Other States, also known as the ICSID Convention. The term investment is there, and it's a key requirement for a tribunal, an arbitral tribunal under the ICSID Convention, to be able to exercise jurisdiction over a dispute, and the dispute has to arise directly out of an investment. Now, the term investment is, funnily enough, kind of strange, but it is not defined in the ICSID Convention, which is curious when the whole treaty is about protecting foreign investment. And so tribunals have had to come up with what do we actually look at when we try to work out, is something an investment or not? And tribunals have not directly gone to something like the OECD benchmark definition on foreign direct investment, but they have looked at very similar features, that where there has to be a substantial commitment for a long-term duration, and where the direct investor is sharing in the risks of the transaction. We'll come to that later. But we begin with the economic definition of a foreign direct investment, because that has a great impact on the type of economic activity that is protected under these treaties. Now, international law I'm sure you all have some knowledge of public international law, but international investment law is like a sub-branch of public international law. And although it is today mostly regulated and contained in treaties, there are many bilateral treaties for the protection of foreign investment and for the promotion of foreign investment. And there are also multilateral treaties for the protection and promotion of foreign investment as well. And under these treaties, the provisions of some of these provisions reflect customary international law, but under these treaties, you generally find that states will have an obligation to promote investments coming from nationals of the other country, which is a state party to the treaty. The states will have an obligation to provide certain substantive guarantees of protection or certain standards of treatment to foreign investors, and they might be obligations such as the obligation not to discriminate against those foreign investments and not to expropriate foreign investments or investments owned by foreign nationals. And then there's also quite often an obligation on the states to agree to resolve disputes arising out of investments through a procedure known as international arbitration, which means it goes to an international tribunal, not to the country's own domestic courts. And so there's a perceived independent tribunal appointed of independent arbitrators, not national court judges. Now, as I've said, for the most part, these types of obligations are contained in treaties between states, which are often bilateral treaties and known as BITs, bilateral investment treaty. But there are also multilateral treaties, such as some that Indonesia is a party to, including the ASEAN Comprehensive Investment Agreement. Also, ASEAN has a range of other treaties with other countries, such as the ASEAN, Australia, New Zealand Free Trade Agreement, which contains an investment chapter as well. And Indonesia has a bilateral agreement with Australia, a bilateral investment agreement with Australia, in addition to the ASEAN treaty with Australia and New Zealand. Now, BITs have been around since the late 1950s, and there's now around 3,000 of them. And for the most part, originally at least, they were typically negotiated between a capital exporting country, so a wealthier country, and a developing country. And that was usually because of the understanding that the capital would flow from the wealthier country to the developing country. That is no longer the case, but these investment treaties have that kind of relationship where there's an OECD capital exporting country and a developing country as the other state party. Now there are investment treaties between countries which are between two developing countries and between two developed countries, etc. There's no longer this kind of typical dichotomy in who the countries are. Now let's have a look at foreign investment flows. This is taken from an UNCTAD publication, the United Nations Conference on Trade and Development, which produces an annual World Investment Report, which reviews the situation of how many, what are the levels of investment flows around the world as well. And you can see that in the last year, as a result of COVID-19, and this data is up to date as of the end of 2020, there was a significant drop off in foreign direct investment last year, which is attributable to the COVID-19 global pandemic. It's around a 35% reduction in foreign direct investment flows around the world, which has taken foreign direct investment flows as of last year back to, I think, the lowest point since 2005. You can compare what happened with a dip. I don't know if you can see my cursor. I hope you can. There was the global financial crisis in 2008, 2009, which resulted in this kind of trough here before the world economy began to recover. And then there was a high point in 2016. And then there was another bit of maybe a correction here before the COVID-19 pandemic struck. What's interesting, though, is that where foreign direct investment flows have dropped off, it's mostly, or there have been something like a 58% drop-off in investment flows to developed countries and to countries in transition, but only quite a mild drop-off of foreign direct investment into developing economies. Now, this grey line at the top is the overall figure. So still there's an overall drop-off in foreign direct investment flows around the world, but developing countries have not felt the same drop-off in inflows of investment as developed countries and economies in transition. And if we look at which are the countries that attract most of the world's foreign direct investment, it is the number one country is the United States, and has been for the last 2 years. Although look at the drop-off compared with the 2019 figure with last year's figure. The top figure is the $156 billion of FDI into the United States, but in 2019 it was this level. Other countries have not experienced the same drop-off. China and Hong Kong both increased their level of FDI. Singapore had a drop-off. India managed to increase it. Luxembourg had a significant increase, and you can see the rest of the figures. But a lot of these are some of the developed countries like Germany, Ireland, and Mexico. You can see there had a drop-off in foreign direct investment. Now, as for outflows, so where does the money come from in order to be invested in other countries? The leading exporter of foreign direct investment in 2020 was China, followed by Luxembourg, and then followed by Japan. And you can see that there's been a bit of movement in terms of where these countries were in the previous year. So Japan was the leading exporter in 2019, but look, its outflows of investment almost were cut in half due to COVID-19. And the United States is around the same, but Germany also had a significant drop-off, 139 billion US dollars going out the door in 2019, but only 35 billion last year. Okay, so this gives you an idea of the sort of the top 20 destinations for foreign direct investment and the top 20 sources of foreign direct investment around the world. Now, going back to these treaties that contain these obligations, these are largely based on pre-existing rules of customary international law that all states have to comply with anyway. So there are, under customary international law, which is a source of international law that is binding on all states, states have obligations regarding how they treat foreign nationals. There are rules concerning when a state is responsible for conduct which takes place within its territory. And there are also rules of customary international law which say when a state is able to seek to enforce rules of international law when one of its nationals has been badly treated and may be treated in a way that is a breach of an international obligation. Now, the customary international law rules, as I said, apply in any event, but what the BITs do is that they give more clear content, perhaps to the obligations, and they introduce new obligations in addition to the general obligations of treatment of foreign nationals. Now, the general standard of treatment that the obligation that states have under customary international law is to treat foreign nationals in a way which is consistent with an international standard. This is a long-standing authority from an arbitral award from 1926. So it's not a standard that's measured by each country's own domestic law. It's a standard that is set by international law. And even though the language of this arbitral award talks about states can't do things that are outrageous or in bad faith, this is in more modern times understood to be equivalent to a standard of reasonable behavior and based on rational policy making. There's also under customary international law a prohibition on expropriating the property of a foreign national. And there are rules under international law concerning if it's not the central government that does something, but a regional government or a local government, or if it's the courts that make a court decision that has the effect of discriminating against a foreign national, when is the central government responsible for that, the part of the government that's entered into the treaty. And there are rules of, this is called rules of attribution of conduct. And the third point here, the rules of diplomatic protection, these tell us under customary international law that if a state considers that one of its nationals has had their rights breached under international law, it can espouse the claim, adopt the claim of its national, and present the claim against the state, which is, it thinks, breached the international law obligation. So this is the background to investment treaties, that there are these rules of customary international law that bilateral investment treaties build on, to a certain extent incorporate, and also build on and introduce new, better defined obligations and better defined standards of treatment that foreign nationals and foreign investors are able to benefit from. Now, there had been previous attempts prior to sort of the negotiation of these bilateral investment treaties. There had been attempts to agree on a multilateral treaty, like we have in the context of the other branch of international economic law. We have in international trade law and the WTO, we have the WTO covered agreements, like the General Agreement on Tariffs and Trade, sets out universal standards for all members of the WTO on what types of restrictions they can have for access to their trading markets for other countries. They are all multilateral treaties, but typically in the world of international investment law, states have just got these bilateral treaties and some more modern regional multilateral treaties. There were efforts in the 1950s and 60s, and even then again in the 1990s, to agree a multilateral treaty on foreign investment protection, but all of these efforts failed. They weren't adopted. States couldn't reach agreement on the substantive obligations, and there have been a lot of disputes at the policy level between wealthier capital exporting countries and developing countries about what the actual obligations are under customary international law and how they should be implemented into treaties. Now, it's a bit of a contradiction to say that there is a disagreement between, or there has been historically, a disagreement between the capital exporting states and capital importing states about the content of customary international law, because all of these countries have, by and large, agreed to standards that have been written into bilateral investment treaties. And so the debates that were happening in the UN General Assembly in the 1960s are really the thing of a bygone era and a relic of the past, and no longer current disputes about the content of states' obligations under international law as regards foreign investors. We've moved on from then, but in the 1960s, those debates prevented the adoption of a multilateral agreement on investment protection. And so states began negotiating bilateral treaties in the late 1950s, as we saw. This continued in the 1960s, 70s, and 80s, and certainly in the 1990s, there was a great acceleration in the negotiation of bilateral investment treaties. And this came as a result of the sort of the opening up of Eastern Europe, of the break up of the former Yugoslavia, the former Soviet Union, and the opening up of many of the Latin American markets as well, where all of these countries wanted to attract foreign capital. They wanted to attract foreign investment. They were developing countries. They needed new roads, new hospitals, new airports, new ports, new electricity supply services, new gas supply services, and they didn't have the money to build them themselves. And they saw the way to get those things done was to attract foreign investors to come into the country and come with their money and their capital to build all of those basic infrastructure facilities. And a way of attracting them was to negotiate investment treaties just to assure foreign investors that they would have protection in the event of any kind of dispute with the host state. And anyway, there's a cover of a book that I edited a number of years ago, which contains commentaries on model investment treaties that states used to negotiate. Now, as regards Indonesia has negotiated a number of bilateral investment treaties, and these have typically included a requirement that as is typical of many countries, that once an investment is made, they're all subject to Indonesia's law. And Indonesia also has a typical provision in its investment treaties that provides that the Indonesian Investment Coordinating Authority, the BPKM, has to give approval for foreign investments that are made in Indonesia. I've listed there a number of substantive protections in most BITs, and I've mentioned a few of those already. No expropriation without compensation, the obligation to provide fair and equitable treatment, most favored nation treatment, which is also an obligation found in trade treaties, WTO treaties as well, and also the obligation to agree to go to arbitration in the event of an investment dispute. Now, here's Indonesia's sort of the state of play with Indonesia's BIT as of this afternoon. There's 72 bilateral investment treaties, but only 26 are in force. Quite a number of Indonesia's investment treaties have been terminated as a result of a program in recent years to terminate bilateral investment treaties that were entered into maybe 20 years ago, maybe 30 years ago, that are quite old style investment treaties, and to renegotiate or update them. And so even though there were quite a lot of BITs negotiated, less than a third of those are still in force today. And if you look at some of Indonesia's more recent treaties, they are with Singapore, with Australia, and then the regional comprehensive economic partnership agreement from just last year, and the Korea-Indonesia CEPA, which is a comprehensive economic partnership agreement, which is also quite a recent treaty. Let's have a look at some more figures of how many claims there have been. So one of the things I mentioned was that in these treaties, there is typically that the foreign investor typically has a right to bring a claim in international arbitration against the host state if it considers that its obligations, the host state has breached its obligations under the treaty. And there have been, as of the end of last year, more than 1,100 claims made against states under these bilateral investment treaties. You can see the first claim was in 1987. That was a claim brought by a Hong Kong company against the government of Sri Lanka. And then there were a few years with no claims at all under these treaties. And then with the advent of and the coming into force of NAFTA, the North American Free Trade Agreement in the mid-1990s, there were a number of claims in the late 1990s, mostly from NAFTA. And then we saw a real explosion in the sort of just after the year 2000. And these were a lot of claims that were made against Argentina as a result of an economic and financial crisis that Argentina had in 2001, 2002, 2003. Argentina has faced about 60 claims, more than 60 claims. It was that episode, a particular economic and financial crisis in Argentina, that really led to this boom in investment treaty arbitration, where we see, brings us to today, where we see just under 70 cases last year. There was a high point in 2018 with about 85 cases. But you can see that there's a fairly steady trend of 50, 60, 70 cases per year brought under these treaties against states. So here's the sort of most frequent respondent states. Overall, it's Argentina, but the chart on the right is just the last 10 years. And interestingly, the state which has been sued the most under these treaties in the last 10 years is Spain. And I say that is kind of interesting because it's a capital exporting country, a developed country. Normally claims are brought because of some kind of act of poor governance in the host state, that there has been an act of discrimination, or there has been a foreign investor has found their property has been expropriated and they've not been compensated for it. Those types of things are quite rare in developed countries or OECD member countries, but Spain is facing a lot of these claims over the last 10 years because of some reforms it made to its energy generation sector in the last decade or so. It had promised to and provided incentives for investors in the solar power industry to come and make investments in Spain because it was going to pay them generous subsidies in return for doing so. But then it cancelled those subsidies by legislation which left a lot of foreign energy companies quite upset and bringing claims against Spain. Now, Indonesia has only faced 7 of these claims, even though it's had 70 or so BITs, albeit there's only 26 in force now. But Indonesia has a reasonably good record in not having been sued a lot by foreign investors under these claims, compared to Argentina, Venezuela, Spain, Czech Republic, Canada, India, etc., has faced a lot more cases. Now, the home states of the claimants are overwhelmingly the most frequent home state is the United States, followed by the Netherlands, Germany, and these states. This is not really surprising to see that capital exporting countries are the typical state of nationality of the foreign investor, which is bringing a claim under a bilateral investment treaty. Okay, moving along. Okay, Indonesia. There's a nice article that's been written by a colleague of mine at the University of Sydney, who is maybe known to some of you, Simon Butt, who is also a professor and specialist in Indonesian law. But Indonesia has been involved in, I guess there's been 9 or so cases under the ICSID Convention and 7 under bilateral investment treaties. Going back to the 1980s, all this was a claim under a contract. The first few of these claims were under contracts, so not an investment treaty dispute, but a contractual dispute that was heard by an ICSID tribunal. But there have been a number of more recent claims where there have been claims brought under treaties, under the UK Indonesia BIT, the Netherlands Indonesia BIT, the Organisation of Islamic Conference Investment Agreement, the UK and Australia Indonesia BIT, the Singapore Indonesia BIT, and the India Indonesia BIT. And Indonesia has done quite well. It has not been found to have made a lot of egregious breaches of investment treaty obligations. There have been successful defenses of investment treaty claims, including in this last one here, the Indian metals and ferroalloys case. I had the honor of being one of the lawyers representing the government of Indonesia in that case before the investment tribunal. And we had a comprehensive victory against this Indian company, which brought a claim against Indonesia, arguing that it had been treated badly in its investment in the coal mining sector. So here's Indonesia's current policy, which is to terminate its bilateral investment treaties and to renegotiate them. And it carried out a fairly extensive review of consultation process of what it should be doing, consulted widely around the world, and it has talked about proposing a new model bilateral investment treaty, which would form the basis of its future negotiations. And also, Indonesia has been actively involved in work before an UNCITRAL working group, which is looking at the reform of investor-state dispute settlement and replacing a proposal to replace all of the ad hoc arbitral tribunals, which are appointed for every individual dispute, with a permanent investment court, which is still an idea that is under negotiation. But Indonesia explained in the context of this working group what its current policy is, and that is to review its existing investment treaties, to modernize them, and to have a better balance between the rights of the host state to regulate the economy and adopt regulatory decisions and the rights of foreign investors. Okay, so there are a number of, I guess I've explained already the Indonesian practice in terminating BITs, and a number of these BITs with some of the states had already been renegotiated. And so there were there were BITs with Denmark and the Netherlands and Germany, which have been negotiated a number of times. Just to look at the some of the general content in Indonesia's quite recent bilateral comprehensive economic partnership agreement with Australia, which has an investment chapter in Chapter 14. there is some quite modern provisions there, which step away, I guess, and are great improvements from the provisions that were in an earlier bilateral investment treaty with Australia, which was negotiated in the 1990s. It gives a much clearer scope of application of the treaty and excludes government procurement decision-making. It also excludes claims that might be made in response to subsidies that are granted by either of the states that is a party to the treaty. It makes it clear that the most favoured nation obligation is limited in scope to substantive treatment and doesn't apply to any procedural advantages or perceived procedural advantages that might exist in different treaties. It clarifies that the obligation to provide fair and equitable treatment and full protection and security are limited to obligations under customary and international law and don't create some kind of independent additional right under the treaty where none existed before. And it also defines in Article 14.11 that the obligation on states not to expropriate unless compensation is paid is limited by the application of the police powers doctrine, which recognizes that where a state adopts regulatory actions which are not discriminatory and which are adopted in the interest of the public welfare, they do not amount to an expropriation. And so this was, I guess, a live issue for Australia a number of years ago, where Australia adopted legislation requiring that tobacco products be sold in plain packets. So it's called plain packaging of tobacco products. So no logos, no trademarks, no advertising, just a plain packet. And Australia was sued by a tobacco company, Philip Morris, under a bilateral investment treaty. Now, Australia defended the claim on a jurisdictional issue, but had it gone to the merits, Australia would have argued that the obligation not to expropriate didn't extend or didn't apply in circumstances where Australia had adopted a public welfare measure for the protection of public health, which was this, such as this plain packaging requirement that was adopted in Australian legislation. I'm conscious of the time, so I'll keep moving along, but there are also interesting dispute settlement provisions concerning the investor-state dispute settlement procedure. And one of those is that there is an obligation to have consultations between the investor and the host state. And then also, if the host state wants it, there is a mandatory obligation to go to conciliation or mediation between the investor and the host state. And that is quite a radical, novel step to take in an investment treaty, because there are very few investment treaties, I think maybe one other, where there is an obligation to have compulsory mediation if the host state requests it prior to the investor being able to commence an international arbitration proceeding. Okay, so I explained earlier about the reforms in the context of Working Group 3, where states are trying to work out whether it would be beneficial and feasible to have a multilateral investment court instead of ad hoc tribunals considering individual cases, or whether the solution, a better solution, might be to simply make improvements to the existing system rather than try to take on this very challenging project of creating a new international institution. And there are a whole host of concerns with the current ad hoc system of international arbitration, which I won't go into now in the interest of time. You'll see these slides. I'll circulate them later on. There are basically, states are in different groupings. Those who think we should create a new multilateral investment court with a system of appeals. Then there are those who say we should simply make improvements to the existing system. Then there are a number of states who think there should be no investor-state dispute settlement at all, whether before an investment court, a permanent court, or before an ad hoc system of tribunals we have at the moment. And then there are states which haven't really made up their mind yet as to what the best approach should be. Now, Indonesia's submission in Working Group 3, and I have the privilege of attending these as part of Australia's delegation to these meetings at UNCITRAL Working Group 3. And Indonesia has been quite critical of the current system of investor-state dispute settlement. That's ISDS, investor-state dispute settlement. And it has said that there needs to be improvements to the current system of ISDS in a way that may effectively reduce states' exposure to legal and financial risks posed by the ISDS mechanism. And so Indonesia has proposed a number of potential improvements to the current system, which it probably means Indonesia is more of one of those states which is an incrementalist rather than one which is proposing structural or systemic reform. Now, I know my time has nearly elapsed, and maybe I've even run over by a couple of minutes, so sorry if that's the case. But just to return to the question that we began with, which is how economic considerations can influence the lawmaking process. And there's a number of ways we can probably identify in which that happens. Firstly, we've seen how that economic considerations are completely central to the lawmaking at the international level in the field of international investment law, because the economic definition of foreign direct investment has been largely adopted in how international tribunals have interpreted the term investment as a legal concept. And you can see here's an extract from the Cellini and Morocco ICSID tribunal's decision, which recognizes that the term investment infers that there be a contribution, a certain duration of performance, and participation in the risks of the transaction, which is really entirely consistent with the considerations that economists have under the OECD benchmark definition on foreign direct investment. This tribunal added that there would be another consideration, which is whether the investment makes a contribution to the economic development of the host state. And that is something which is more controversial, but nonetheless, a number of tribunals have agreed with that. A second observation we can make is that where states agree to protect investments under international law, be it customary international law or in bilateral or multilateral investment treaties, those obligations that states have at the international level have to be incorporated into domestic law. And so if states don't implement their international obligations domestically, they may well act in a way which is in breach of their international obligations. And therefore, a lot of domestic lawmaking follows on from international commitments that states have at the international level. Thirdly, it has been said that the existence of international obligations on states, whether under customary international law or under investment treaties, to accord certain treatment to foreign nationals and to foreign investors, that is said to be a way of promoting better governance at the domestic level, from which all people in that country will benefit. It's a way of promoting the rule of law. It's a way of promoting good governance, because states don't want to be in breach of international obligations and don't want to be taken to an international court proceeding before an international tribunal. And so states are more careful now that they have seen that there have been 1,100 of these cases where in maybe 50% of those, the state has lost and been ordered to pay compensation. States are much more careful to ensure compliance with the rule of law within their own domestic jurisdiction. And fourthly, the system is not perfect. It has many problems, as has been recognized in UNCITRAL, Working Group 3, by many states in the room. And this is all work in progress as to how the system of investor-state dispute settlement could be reformed, and what the ideal is that we should be working towards in the next few years. I will leave my comments there, and thank you very much. And I'll stop screen sharing, but thank you very much for your attention, and I look forward to a discussion if we have time for that. Thank you.
Thank you, Pak Chester. Again, we have a lot of issues and a lot of new knowledge that we got from Pak Chester, I hope. I think because it is economic international law perspective, yeah, particularly economic international investment, that's Pak Chester has already mentioned. I don't want to conclude it because I think the last slide actually, Pak Chester tried to answer the questions directly, which is mentioned that economic interest is actually equally centralized of the lawmaking process in international level, which actually for those countries who involved with or ratify the convention, it actually lead us to revise our law and policy so that in line with different kind of multinational treaties. But I think it's very interesting. There are more than 3,000, 3,000 treaties. And then from the perspective of Pak Chester, Indonesia is quite good, in a way how to, to develop the law investments, legal policy on the investment. And then Pak Chester also mentions about there are 7 cases that goes to Indonesians. There is a dispute. It is quite low compared to other countries. So there are a lot of things that Pak Chester also mentioned before, but I do believe that you already make a note by yourself. But before we open to discussion, I want to give us some point in Bahasa Indonesia. So because I think we don't have any translations today, and some of our friends perhaps will lead them to more understand, to conclude it in Bahasa Indonesia. Teman-teman saya kira dua pembicara ini sangat menarik ada 2 perspektif Perspektif pertama tadi disampaikan oleh Pak Rimawan, kita bicara tentang economic justice, bagaimana sebetulnya Indonesia dalam periode sebelum 2019 telah menemukan adanya perkembangan yang sangat signifikan yang sebetulnya inline dengan berbagai international instrumen terkait dengan clean, transparan, anti korupsi, sustainability itu bagian dari satu aspek yang sebetulnya Indonesia inline with sudah mulai menyesuaikan dengan berbagai international standard yang sebetulnya sangat penting untuk perkembangan ekonomi Indonesia yang berkelanjutan. Tapi tadi Pak Rimawan menyampaikan bahwa ada stagnasi sejak 2019 ini, kemudian ada perubahan yang sangat drastis sehingga ada banyak aspek yang sudah dimulai itu tidak kemudian berjalan lagi. Jadi kita mengalami destruksinya bukan hanya teknologi COVID, tapi tadi soal isu destruksi soal korupsi dan destruksi karena Undang-Undang Cipta Kerja yang menurut Pak Rimawan tadi sangat berbeda dengan semangat awal yang sebetulnya sudah sangat baik. Nah, Pak Chester itu bicara dari perspektif international investment law Jadi bagaimana sebetulnya Indonesia itu sangat berpengaruh. Indonesia sebetulnya bagian dari international law yang kemudian sangat aktif di dalam upaya untuk juga bagian dari upaya untuk tadi Pak Chester kan bilang ada eksportir, ada importir dua negara yang sebetulnya sama-sama upayanya merasa penting untuk memiliki standar-standar atau mematuhi standar-standar internasional terkait dengan investment. Dan tentu saja dari perspektif investor ada keinginan untuk pasti upaya untuk melindungi kepentingan-kepentingan investor, sehingga kemudian itu adalah bagian yang juga ditekankan di dalam agreement. Tapi tadi menarik sekali Pak Chester malah bilang ada 3.000-an dan Indonesia sebetulnya banyak terlibat dalam treaty tersebut, bahkan juga yang paling sering adalah dengan bilateral treaty yang antar negara. Tapi dalam perspektif international trade investment trade law ini sebetulnya Indonesia relatif dianggap cukup baik karena sebetulnya ada upaya-upaya untuk perbaikan kebijakannya dan untuk kasus tadi Pak Chester bilang hanya ada 7 kasus saat ini terkait dengan dispute yang mempertanyakan tentang ketidaksesuaian kebijakan Indonesia terhadap kebijakan internasional investment. Tapi intinya bahwa Pak Chester menyimpulkan ada memang kepentingan ekonomi itu menjadi sentral dalam membentuk kebijakan-kebijakan global terkait dengan ekonomi ini, terkait dengan kebijakan global tentu saja dengan investment ini, dan sebetulnya sudah banyak. Saya kira itu kesimpulan sementara. Nah, saya akan buka sesi I will open the sessions now to invite you to give a comment and question And I think there are already several questions asked to Pak Chester and Pak Rimawan. So today is quite a lot of students. Yeah, actually, I don't believe it's all students. So we only have 84 students who take this class, but I found that there are more participants perhaps from outside class. So it's good. So now I will open the session. So if you want to have a question, just raise your hands with a reaction. And then before that, I will invite also several students who will give a direct question, but please, you only need to say it in 1 minute. Yeah. So everyone, so there is Kanti Pertiwi. I believe Kanti Pertiwi is not from UGM, but I want to invite her to give a comment first. And then there is from Kanal Hukum. There is another question for Pak Rimawan. And then also Pak Chester. Yeah, and then from Oki and from Wildan. Yeah, I think I'll give a time first for Kanti, Oki, and Wildan. But the other two questions, perhaps Pak Rimawan and Pak Chester can directly respond it because it is came from the other platform, not directly from the chat. So time is yours, Bu Kanti.
Halo Mbak I, aduh jadi
Halo.
ngomong nih.
Ya, silakan.
Aduh, thank you so much. Thank you for organizing this talk ya Mbak Iyi. Halo Pak Chester and Pak Rimawan. Salam kenal. My name is Kanti. I'm a lecturer at Universitas Indonesia and based in Faculty of Business and Economics. But obviously, this topic we have today, it's very much interdisciplinary. So that's why I'm here, and I appreciate all the interesting things that you've presented and shared with us this afternoon. So my question, I already put my question in the chat, but if you want me to read it out, I can do that too. So there's a book titled The Social Construction of Global Corruption by Katsarova. I think it's pretty recent, 2019, which offers a thorough analysis on the shift of discourse surrounding corruption, where in the 1970s, corruption is about regulating excessive influence of corporations on the state, and in late 90s becomes about monitoring the conduct of the state, which shows the political dimension of the so-called war on corruption. So in simple terms, all conventions and standardizations regime that we see today cannot be separated from lobbying activities by mostly US-based corporations in multilateral forums. So it's a very good book. I think if anyone's interested in this topic, you might find it very useful. So my question is, do the panelists, Pak Rimawan and Pak Chester, have any thoughts on that? I think that's it, Mbak I. Thank you so much. And sorry, I'm not able to turn on my camera.
It's okay, Mbak Kanti. Thank you for the question. So I invite now Oki.
Yes, thank you, Bu Yi.
Yes.
Well, my question is for Professor Chester Brown. Nice to meet you, Prof. And well, my question is, I'm going to start with, from my point of view, as a practicing lawyer, I'm a corporate lawyer, and well, the law plays a significant causal role in development. And Thomas Carothers said that establish once and for all the rule of law. But to be fair, those ruling laws are based on political interests of the parties. The only way for the people to challenge such laws is through the Constitutional Court or by the interpretations of judges through their judicial precedents in cases. Indonesian judges tend to put legislators' interpretations of the law in their ratio decidendi, which states power possessing the authority to interpret the law in Australia, the legislators or the judges. Thank you, Prof.
Thank you, Oki. And then I believe that there is Wildan. Yeah. Wildan, would you mind to also voice this your question directly? Oh, are you here, Wildan? Yeah. And then I think beside Wildan, there are two chat. Yeah, one for Pak Rimawan. Yeah, is it related to the influence of the USA with tapering and indication of the rate of interest in China? Yeah, and then with regard to fail in payment Evergrande, so in obligations market. So what do you think Indonesia can mitigate the spillover effect? Yeah. So how to synchronize the policy task force 115 in Natuna with Vietnam? So there's a question for you, Pak Rimawan, and then from Pak Chester, I think the law plays a significant cause role in development. I think this is from you, yeah. Okay, no? To be fair, yeah, I think that's from Oki and then the other participant. I think time is for Pak Rimawan first and then Pak Chester. Only perhaps 5 minutes, 5 to 7 minutes. Thank you.
Okay, thank you. Thank you for the question, Mbak Kanti. It's very interesting. It's very nice. It's a good question, this one. But then if we take a look again, the way the legislation works, especially how we develop the legislation, especially in the anti-corruption. We haven't touched the discussion in 1970s in that book. Basically, we not even we not even regulate what I call the private sector corruption. So in these circumstances, it's very difficult actually if we take a look of if we trying to reflect again, what is the implication or the role of the corporation, especially to the politics, because in these circumstances, for state-owned enterprise is very, very highly regulated, but then for the private enterprises, it's just almost free. There's nothing that you can stop them on doing so many wrongdoing. Is what I call is considered as a corruption. So that's I worked myself involved in some of the corporation. I remember in 2017 we tried. It was in an insurance company, and then we tried to emphasize that why don't we trying to find clients from private sector instead of from the state-owned enterprise. But when we try to do that, we just stop less than 1 hour, less than 1 year, we just stop that operation. Why? Because there are so many practices that they can do, but we cannot do. So, because we were bound by the regulation, they don't. So that's very, in terms of the environment is very murky at that time, and up until now, and that's create difficulties for us, to operate. Now you can imagine, if we based on my database, 59% of the value of the corruption in Indonesia is attributable by the private companies, but then we haven't have any anti-corruption law that stipulated directly to the private corporation. But then the question is that what would happen if we try to regulate the private corruption? I believe the numbers will be soaring, increasing dramatically, and that's so. The book, it's nice, but then in terms of the Indonesian context, it seems to me that even in 1970s in the USA, we haven't reached that state as yet. Thank you.
Thank you, Pak Rimawan. Time is yours, Pak Chester. 5 minutes to 7. Thank you.
Yeah, thank you very much. But very interesting questions. Thank you very much for those. I'll begin just with a further maybe comment or a footnote on Kanti's question about how to combat corruption where so much is about lobbying activities of foreign corporations, and that's very difficult to regulate. I think there's a international cooperation is one part of the equation, and there's the UN Convention Against Corruption and the OECD Convention Against Corruption, and there's also a regional Council of Europe Convention against corruption of foreign public officials as well. And those international multilateral instruments provide a lot of guidance for states, and if states are obviously minded to enter into those treaties and accept those obligations, then they provide guidance on how states can implement their provisions and deal better with corruption at the domestic level. The main problem as I see it, and corruption is, I suppose, not a field that I work in anywhere near as much as many other people, but is a problem of lack of capacity at the domestic level, and lack of capacity of many countries to enforce the laws that they do have. And so while there might be many countries that are members of these conventions and have accepted the obligations and have even managed to implement them in domestic legislation, I think a problem of law enforcement at the domestic level is a great concern. And that is where countries can, with the best will in the world, have signed up to many multilateral treaties or regional treaties or bilateral treaties that deal with, that seek to address these very important issues, and have implemented them in their domestic legislation, but simply lack the ability to police them and ensure compliance with them. And so while there may be untold stories of endemic corrupt activity in one country or another, that country may only have a police force of several hundred people, may only have a business sort of investigation unit of part of its police force of a dozen people, and they may only have the resources to prosecute 2 people per year, even though they may know that there are several thousand alleged violations of the legislation every year. And so law enforcement is a great problem, and that's why one of the pillars of the United Nations Convention Against Corruption is about capacity building, and ensuring that those countries that maybe find it easy to comply with their obligations and have been able to implement them and ensure compliance within their own jurisdictions, provide assistance to other countries, technical assistance and facilitation assistance to other countries, so that they can hopefully ensure compliance within their own jurisdictions. So that's my tiny sort of footnote to add on to Rimawan's comment. Oki, as for your question, it's a very, very deep question. It made me scratch my head and think about it, because really it's all about who interprets the law and who tells us what the law is within a different country. And I suppose a general answer is that this will depend on each country's constitutional arrangements as to whether there is parliamentary supremacy, or whether the courts will have the final say, or whether there is some other kind of body that may be able to rule without the need for parliament or without the need for the courts. As for in Australia, I suppose I would like to say the general answer is that the courts interpret the law. Parliament, of course, makes the law, and the courts then will be called upon to interpret the law, and the courts will apply the law except where the Parliament has gone beyond its constitutional powers. And so we have a federal system of government in Australia, where there is a Commonwealth, the Commonwealth government, the central government, which is based in Canberra, which has a parliament which only has certain specific powers that are enumerated and listed in the Commonwealth Constitution. Then there are the state and territory governments, and the state parliament within each state has plenary powers. There are no real restrictions on the powers of the state and territory parliaments, except if there is a conflict between state legislation and Commonwealth legislation, the Commonwealth legislation would prevail. But if the Commonwealth Parliament adopts a law which goes beyond any of the powers that it has conferred on it under the Constitution, then the High Court of Australia can rule that legislation to be unconstitutional. There are also circumstances in which even state legislation can be challenged by Court of Australia, and the state legislation can be found to be unconstitutional. So I suppose the ultimate decision maker and ultimate authority on telling us what the law is with the High Court of Australia would be conflict with in a different constitutional context where the Parliament is supreme and Parliament can overrule courts. I hope that answers your question, but a very good question. Very good question indeed. Thank you.
Thank you, Pak Chester. Now is the Azan. Azan here is quite, everybody couldn't hear anything. So in 2 minutes, we have a break. Yeah, and after that, we will continue. 2 minutes, and then we will proceed more question and answer. Thank you. All right, I think it's already okay now. So thank you for the response from Pak Rimawan and Pak Chester. So I think there is always a negative connotation when we discuss about the economic interest. It always like skepticism whether economic interest sometimes in contradiction with social justice. So according to Pak Rimawan and Pak Chester, later on, is there any possibility to, to enhance the economic justice with, social economic justice, equality, and then which inclusive for anybody? So is there any possibility to do that in this future? Because if we talk about, oh, this is economic interest, it means that it is not for the poor. It is not for every society. It is not for the member of those who are perhaps, quite, middle lower. So that's one issue that perhaps later on Pak Rimawan and Pak Chester also responds about it. So there are 3 other questions from Pak Agus, yeah, and then from Pak Gede, yeah, and also Gilang. I think I give you 1 minute each. Time is yours, Pak Agung. Mas Agung, silahkan.
Thank you, Ma'am. My question to Sir Rimawan, I think Indonesia has not ratified the OECD Convention. Even though the OECD can make it easier for Indonesia to enforce bribery action against foreign public officials. My question number 1, should Indonesia country ratify the OECD Convention? Number 2, how is Indonesian law enforcement against transnational crimes, bribery, of foreign public official, particularly economic crimes? Thank you, sir.
Thank you, Mas Agung. Pak Gilang, Mas Gilang, silahkan. Ya, Mas Gilang. Do you have any problem? We are, I think, yeah.
Okay, we can read, yeah.
Yeah, now, okay, it's good. Ya, Mas Gilang. Okay, while Mas Gilang prepare for the question, I think I will invite Pak Gede, Mas Gede, Mas I Gede, ya silahkan.
Ya, terima kasih sebelumnya saya ucapkan salam dan terima kasih kepada Uji, Pak Rimawan, dan Profesor Brown. It's very interesting presentation about matter. Give me such insight. I'd like to ask Prof. Brown about, correct me if I'm wrong, about obligations. Well, as I know, it depends mostly on ratings, because the rating itself will set the standards about the obligations, such as held by Moody, Finch, etc. but there is no regulations regarding this institution appraisals that is not reflected such as it is such in private sector, like in Japanese synthetic CDO and etc. How can developing countries that is mostly affected by such misappraisal can claim the losses or opportunity costs that may occur? Thank you very much.
Mas Gede, the sound is not really clear, but I think you have already made a chat, yeah? I think that's okay. So
Yeah. Okay.
I'll give time for Pak Rimawan 2 minutes, and then Pak Chester 2 minutes. Thank you.
Okay. Before that, I think I got a question before regarding the, oh yeah, this is the OECD, yeah? So regarding this OECD, well, we are not OECD countries, yes. But then we need to understand that our economy is actually, Indonesian economy is a small open economy. When you play with it as a small open economy, then you need to see very, very carefully about where the winds goes actually, when the wind blows, yeah, because you need to see that and then adapt accordingly. Now, if we see the history in Europe and OECD country, they have reached to the point where in their economic policy, they also incorporate the environmental needs in the sustainability measures and etc. That is totally different from us. Okay. Now the question is that will it be possible for us to follow through that? Because that's good. You know, when we talk about sustainability, it means that we're talking about long-term business. It's not only short-term business, and this is good for us. If this is so good for us, why is it that we don't embrace that? That the same thing, you know, our experience, you know, when with the ISO 37001 and also the anti-bribery accreditation, basically by the ISO, and also even the KPK has that. So I urged at that time, you know, the insurance company that I became the commissioner to embrace the anti-bribery measures. At first, even the director said that, well, that will be a contraction to us. And then I said, yes, that will be a contraction. But then the benefit will emerge because those who are do wrongdoing, they will not join with us. And it's true. After we join that, and then what happening is that because we improve the quality of the institution, and there are many agencies that previously they are not embraced the good corporate governance so highly, so they prefer to leave us, and then afterward it will be replaced by those who the agencies that actually embrace the good corporate governance. So it's just a matter of choice, you know, whether you want to do it or not. So this is the situation that we should try to think in that way, because if we just follow what's going on, what we have at the moment, we never ever think about the sustainability. We never ever think about how the people, especially the masyarakat adat, yeah. What is masyarakat adat? So that's traditional people. They will be they get the benefits from economic activity, for instance. But then now this is something that we need to think about, to think it through. Actually, the position to be the followers is much easier, because what you can do is just, you know, you're trying to imitate something that's a best practice, and you don't need to go through the process that's has been is a long and winding road that has been done by many countries in OECD. The second one is about the transnational crimes against bribery of foreign public officials. Now, again, you know, because if we don't have the law against that, that will be like an unregulated law. Yeah. This is like unregulated offenses. It's unregulated offenses. There's nothing you can do. It's just like you know, between private to private company, and then they do a bribery, for instance. And then if if you call the who's that, Mas Baswedan, to witness that, there's nothing he can do. He cannot catch anything. The best the KPK officer has, if they seen the private to private bribery, is there anything they can do? No, because there is no legislation that rule about that. So that's the problem. It's the same thing occur for the bribery for the foreign public official. Thank you.
Thank you, Pak Rimawan. It's a very important highlighted. Yeah, what actually it responds my question as well. So, Pak Chester, time is yours. 2 minutes. Thank you.
Thank you. I'll just respond briefly to the question which is in the chat and which was restated by Guy Krishna Charisma. Sorry, I can't see the full name. Charisma one. There it is. Okay, so I see the full name on the chat now. About the obligations or the impact of the ratings agency on certain investment products. And I suppose the first point is that these are questions. This is a question that's not governed by public international law. So if there's any kind of grievance that anybody has, whether it's a state which has issued bonds or a state which has purchased bonds or any other individual which has bought some kind of investment product, some kind of securities, whether it be the type of products that were being sold in the financial crisis of 12 years ago, these collateralized debt obligations. If anybody has any grievance with the way they are rated, and the rating agencies are perceived to be at fault, and that's a claim that person has against that ratings agency under some kind of domestic law. Probably there'll be obligations under consumer protection law concerning their role as in the securities market, probably under New York law where most of these are based, and that would be a private law claim or a private law action that would be brought by the state, by the other investor or the bank or whichever it is which is invested in these products. So that's not something that's regulated by investment treaties or by customary international law. If the agency which was giving some kind of rating was a state-owned enterprise, if it was a bank of a sovereign, a state bank, a national bank of a state or central bank, if it was some kind of agency over which the state had control, exercised control and was exercising other sovereign functions, then there would be an argument that the conduct of that entity would be attributable to a state, and therefore there might be a claim made against a state arising out of the conduct of that ratings agency, but that's usually not the case. Usually these are private organizations. Thank you.
Thank you, Pak Chester. So now we don't open discussions again. I hope you are okay, because I know that there are students already raise hand and then put another chat. So, but I'm so sorry I couldn't give a time because Pak Chester also need to leave and everybody need to leave at 3 o'clock. But for the last time, I will invite Pak Andi Omara who give comments for all of the discussions. Pak Andi Omara is one of the co-founder of this teaching class with me, Law and Politics. Time is yours, Pak Andi, about 3 until 4 minutes. Thank you.
Oke, terima kasih Bu Iyi. Selamat sore Mas Rimawan. I bet you remember me. Okay, Professor Brown, nice to see you. I enjoy all the talks, basically, because we have multiple perspectives today. Not only because I am a constitutional teacher, so I mostly talks about how the relations with the government and the people and how the relations among state institutions. But today, I broaden my perspective now. So with regard to the relations between lawmaking process and the international interest or international economic interest, I would say that the questions we put today, how far the international entities, especially economics and interest, influence the lawmaking process, it seems that the question is simple, yet it is very complex and difficult to be answered. Because when I heard, listen to both speakers, it is not easy, because in one, I think in one part, we can see that the international entities or the international actor have influenced heavily on how the domestic the domestic or the country like Indonesia have to follow, especially when we talk about the 1999 financial crisis in Indonesia, where with the conditionality put by the IMF as well as World Bank, we have to follow what actually the recipe from them, the good governance principle. And somehow it works, but according to Mas Rimawan, I think it is also sad to hear that it's finished when we reached 2019, meaning that it seems that it is not again the international actor, but it seems to me that it's domestic actor who changed the directions. It seems to me, but maybe we can discuss this later. That also raised my questions, how we address the change or the amended KPK law. We have a very strong KPK in the past, but since the amended KPK law, it seems that we are not really have the strong commitment to combat corruptions anymore. It seems that the new or the updated law seems to weaken the institutions. That would be, again, another contradictory policy when we see the international actor involved in the making of good governance, but in other side, we can see also other actors do the opposite. That would be what we call the fact that we face today. This also happens when we talk about the Omnibus Law. Whether Omnibus Law is actually the influenced by international entities or domestic corporations entity, or it's also involved the employee sector as well as the environment or human rights issues. That also another challenge for us. And in bilateral as well as international relations, I agree with Professor Brown saying that when we intend to join an organizations, in my opinion, sometimes we have to adopt with what actually the association standard to join the organizations, and sometimes that's good. For example, when we talk about BIT, FDI, because we are not like doing things by ourselves, but we have to also make relations with other entities, foreign investors or other countries, then we cannot make the rule by ourselves, but it should be like the joint rules between us and the other party. And sometimes it is not easy to balance between the interests of the host country and the opposite party. That would be another issue when we talk about the investment, because we have two or more entities, and these two or more entities have different or even opposite interests. And that become another issue, how we make a good, fair relations in this regard. And finally, I would say that the examples of terminations of BIT from Professor Brown is also very important. Is it because of the international pressure, or in my opinion, is it because of the domestic actor who choose to terminate the BIT rather than to continue joining the BIT. So I think that would be my comments on these two incredible speakers today. One final says, this is a very complex issue, basically. Okay, thank you, Bu Yi.
Thank you, Pak Andi. I think Pak Andi also make a conclusions about different interesting issues that we have discussed. We know that lawmaking process is a very complex and dynamic process. There are a lot of actors involved in international level with different interests, and then different actors layer by layer. But I think it's a very important highlighted from Pak Andi that international interest perhaps in a good way, but sometimes it leads to a different way, not necessarily only by other parties in international actor, but also in domestic level. So that might be a big issues in Indonesia, because there are a good framework, international framework in order to economic, social justice, sustainability. But when it comes to Indonesia, with the different kind of actors and interests, it might lead to a different situation, which highlighted by Pak Rimawan. So thank you very much, Pak Chester and Mas Rimawan. I think we have a fruitful discussions today, and then we will continue our discussions later for students. We will have another 6 meeting with Pak Andi, so you will elaborate it more later on in class. And then for other participants from outside UGM, thank you very much for attending our serial discussion. And this is a guest lecture discussion. I just want to let you know as well, we do have another seminar for 8th of October, which is seminar, not guest lecture. So it's more likely broad with regard to security and peace in Indonesia and Southeast Asia, in Asia. So this is more seminar. And if you want to join with us as well, you can join, and then you can follow our Instagram to get the information about that. So I will close the sessions, and thank you very much for everybody. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, and then salam kebajikan, and also salam sejahtera and health, salam sehat. Bye-bye, and then times now, and thank you, everybody.